It's 7:01.
7:01.
We are good.
I can call for it. Okay, we'll call to order we're meeting as two boards tonight. So the first meeting is Zoning Board of Review will be our first meeting. This is the agenda. We're opening it now. Today is December 12th, 2023. Call to order, item 1. Item 2, roll call.
Mr. Nigerian?
Here.
Mr. DeZiel?
Here.
Mr. Mostyn?
Here.
Mr. Marcantonio? And Ms. Benoit?
Thank you. Item 3, disclosure of no compensation or pension credits received by board members. We all serve at the invitation of the town council. Item 4, disclosure and notice. Zoning Board of Review members shall disclose any ex parte communications about any contested or material adjudicatory facts or opinions concerning the merits of any application before the Zoning Board of Review. Item 5, approval of the minutes from November 14th, 2023. I believe all of you have had those minutes and plenty of time to review. Do we have any additions, corrections, or comments? Hearing none, can we have a motion to approve the minutes?
I'll make a motion to approve the minutes of November 14th, 2023.
I'll second.
We have a second. All in favor?
Aye.
Opposed? Item 6, I think you all got that this morning. It's the decision, the written decision. ZBR 23-10, Roland G. and Bethany A. Comio at 35 Fountain Street. Was fairly straightforward. So again, if anyone has any concerns, questions, observations? Hearing none, we can have a motion to approve the decision as written for ZBR 23-10.
I make a motion to approve the decision for ZBR 23-10.
Second?
I'll second it.
All in favor?
Aye.
Opposed? Okay, so that passes. Bethany, Vivian, I'll sign that when we leave. I have a copy here too. Yeah, okay. Item 7 would be the schedule of meetings for 2024. Vivian, this is essentially the same thing, just with dates changed to reflect the new year?
Yes, that's correct.
Okay. Are there any questions? Okay, why don't we have a motion to accept the meeting schedule for 2024?
I make a motion to approve the regular meeting schedule for the calendar year 2024.
I'll second the motion.
All in favor?
Aye.
Opposed? Okay. Just as a side note for everyone, which is the next agenda item, because we have an appeal tonight, the board has to sit as two different bodies in two different formal meetings. We are about to ask for the adjournment of the Zoning Board of Review, and then we will call to order the Zoning Board of Appeal. With that being said, can I have a motion to adjourn the Zoning Board of Review?
I make a motion to adjourn.
Second?
I'll second the motion.
All in favor?
Aye.
Okay. And again, the prescribed methodology is that we meet twice, once as the Board of Review when we have business, and then separately as the Board of Appeal. So we'll call to order the Zoning Board of Appeal for December 12th, 2023. Just for formality, we'll do the roll call again, please.
Just a quick question. Do we have to state the time that we're opening this meeting?
We should, for the record. Yeah, 7:05. Call it 7:06. Good observation. Thank you.
Mr. Nigerian?
Here.
Mr. DeZiel?
Here.
Mr. Mostyn?
Here.
Mr. Marcantonio? And Ms. Benoit?
Okay, item 3 is the same as the previous item 3, but I'll state it in brief. It's the disclosure of no compensation or pension credits reserved by board members. Item 4, again, is the same as item 4 previously, which the obligation for ZBA members in this case to disclose any ex parte communications about any contested or material adjudicatory facts or opinions concerning the merits of any application before or any appeal before the Zoning Board of Appeal. Item 5 is the appeal. Before I enter anything, we should just note to board members, you did get, each of you did get a section. Yeah, but you also got the section from our book that indicates the process for appeal. So I just wanted to highlight 4 items so that we focus accordingly, and this is directly from the book. First, we are to rule, item 1 would be prejudicial, if there is prejudicial procedural error. Nothing more, nothing less. Item 2, is there clear error? Item 3, was the decision reached with lack of support of the evidence? Those are the 3 criteria that we all see in front of us and we're compelled by law to abide by. If we need any legal opinions on anything, we'll defer to our counsel. And I would draw to your attention the paragraph above where it states that the Zoning Board of Appeal is not to stand as substitute for the Planning Board in this appeal. It may not be worded verbatim, but you can see that the intent of the directive is that we are not to be the Planning Board, so that's that. What I should probably do is just introduce into evidence. Let me make sure we have what we need here. Just that cover letter, yeah, that cover letter, for some reason I slipped off of this. Oh, that's why, because it's on the other page. Oh, no, I need this one too. So, we'll call A1, I guess for a lack of any other designation. A1 would be the memorandum which was the formal appeal submitted by Mancini and Carter, attorneys at law, was hand-delivered on November 3rd of 2023 is the date. And this is regarding materials concerning the notice of appeal. So that was one document. The second document we received we'll call A2. I didn't go through the pains of counting pages because we know that the office has all of these documents. A2 was from the offices of Kelly, Sosa, and Parmenter, PC, dated November 28th, and that is addressed to the Zoning Board of Review and the building inspector, Mr. Leo Cody.
I just have one question for
what's
Mr. Archambault.
What's that?
Seeing that there's another party that filed papers in opposition to the appellant's papers, should these be marked, I don't know, R1 is like respondents' exhibits, or is it just one big appeal? And
I mean, yeah, we could call it T1, or one is from the appellant and one is from the applicant.
As long as you can distinguish between the
Yeah.
appellant and the
I don't think it
appellee,
matters.
and you can do it
Yeah.
numerically, you're fine.
Okay, so
Okay.
A2,
A2.
yeah, A2 would be from the applicant, if you will, because it's from their attorneys, and A1 is from an appellant, the appellant. And again, that is their brief memorandum in support of appeal. So we have two documents. I don't know, do we have both parties present? We do, okay. I can leave it to the two councils, but since it's an appeal, I would assume we would defer to the appellant to make a brief presentation based on the information you provided.
Sure. Good evening, Mr. Chairman, members of the board. John Mancini on behalf of the appellant and the moving party, essentially. I represent BBWW Properties LLC, which is an abutter to the project which is before you on appeal. Essentially, this abutter has proposed the appeal of a decision issued by the planning board on October 19, 2023. The decision that the planning board issued on that date was for a master plan proposal. Master plan being conceptual plan. And the conceptual plan, which was before the planning board at that time, was to essentially take several lots, merge those lots for the creation of two specific uses. The specific uses would be two essential fast food establishments in the business highway zone. The proposed establishments are by right, meaning that they are permitted within the BH zone. Where the applicant raises issues and concerns are with respect to not the process, but the decision of the planning board itself and the information which the planning board analyzed as the basis for its decision. Specifically, the applicant, or the appellant, I should say, is the owner of Assessor's Plat 21, lots 25 and 29. They are adjacent lots of the very important pieces of a larger parcel, which is part of what is existing there, what's known as Dowling Village. The appeal that we proposed is not a complicated appeal. The process at master plan, as you're aware, is not a complicated process. It's conceptual, and we acknowledge that. Essentially, it's been described by state law as an applicant coming forward and drawing lines on a piece of paper to describe to the board the essential development, proposed development. And the decision that the planning board rendered reflects that, except in this case, it was a bit unique. And the reason why this case was unique is because the applicant, for whatever reason, but I think the reason's very clear, they proposed a traffic study and a traffic report which is submitted. Part of the master plan review process, traffic and traffic studies, specifically engineering documents, such as a traffic study, which was presented in this case by a registered professional engineer, Stonefield Engineering, is not required. But in this instance, it was submitted because essentially approving this project without some type of traffic study, whether it be a study or opinion, would have essentially a devastating impact on the area because of the intensity of the existing traffic that is already on the site. Not to mention the fact that Dowling Village has and was reviewed extensively because of concerns with regards to traffic. And the concerns that this abutter has, BBWW Properties, centers around traffic. And the planning board, in its own decision, really focused on the issue of traffic. It stated in item number 4, when it made its findings of fact, it said that this section of Aggie Dowling Highway, Route 146A, is heavily traveled artery roadway in a dense developed commercial area. That finding of fact is extremely important. And it's in one sentence, the planning board really captures the essence of the entire development and composition of development and the fabric of that area and how it needs to be interplayed. It stated that this section, so it's a specific area, which many of you I'm sure are very, very familiar with, and we can say that it starts where CBS is and it incorporates going north into Woonsocket, which incorporates these lots. And just in that short little area, there's an intense amount of activity. And the planning board stated that they found that the activity was heavily traveled artery roadway in a densely developed commercial area. So that is a finding of fact that the planning board made. The error we believe that the board made is in its decision. So as you heard at the beginning from your chairman, there are 3 prongs essentially that are reviewed. performed by a licensed professional engineer that concluded, quote, proposed development would not have significant impact on traffic operations of an adjacent roadway network. We believe that that finding of fact is A, an error, and B, is not supported by the record. And why is it an error? Well, the planning board essentially accepted a traffic study proposed by the professional registered engineer, which was flawed. And the reason that we say that the traffic study is flawed is because it used the wrong use code. So the traffic study that the planning board relied upon for its determination to make the findings of fact that we've determined, to address the issue of the complexity of the traffic in that area, was premised upon a code which is denoted as land use 930, fast casual restaurant and land use. Instead of code section 937, coffee/donut or drive-through window. The report says that and I read, that rather the drive-through window would function exclusively as an accessory pickup window to service patrons receiving mobile orders, which were processed and prepared at arrival. So the traffic report asserts to the planning board that yes, there's a drive-through, but that drive-through is only going to be for accommodations of mobile orders. So it's not focusing on your average ordinary patrons that come in the morning or come in the afternoon or come in the evenings, but rather it's focused solely on mobile orders. And there was really no further discussion about that or further exploration about that. But that is an important point because you're limiting your traffic to only that issue, or those users, I should say. And there was no condition of approval that the drive-through would be subject to only those mobile orders, that there would be some way to restrict or constrain the use of that drive-through to receiving mobile orders. And this is significant because of that statement. The traffic study decides not to use coffee/donut shop or drive-through, but rather uses a less intense definition or less intense use code, which is fast casual restaurant. It says, therefore, the drive-through window is not anticipated to have a significant impact on the number of trips arriving on the site, nor is anticipated to generate significant queuing on the site. We think that this comment, these assertions were an error which led to the board to commit its own error by making a finding of fact that this traffic study was sufficient to address concerns of traffic. Secondly, the traffic report talks about a use with regards to coffee/donut shop or drive-through window, no indoor seating. That classification was also inaccurate because the proposal is to have both indoor seating as well as drive-through. So the use that's being proposed as part of the conceptual plan review is clearly a donut shop or a drive-through that is intended to be used as a drive-through that we're all familiar with, which is whether you make a mobile order or you don't, you essentially use that drive-through. However, the documentation presented to the planning board states otherwise, and that has a significant impact because it lowers the amount of trip generations and it makes it seem as if traffic is less intense and more compatible with the surrounding area. Finally, the traffic report does not in any way take into account the existing businesses that are at the site, nor does it take into account the other potential uses at the site, nor does it take into account the boulevard itself, Dowling Village Boulevard, and the access way to Dowling Village Boulevard, and nor does it analyze the traffic light at the corner of the Dowling Village Boulevard and where this property is located. So our focus in our papers is that the planning board committed clear error by relying on a report that was inaccurate, and secondly, dovetails into the lack of support. Because again, the traffic study was not thorough, it was not fully analyzed, and it wasn't properly vetted by the planning board when it was submitted. Our second issue is equally alarming, and it deals with the fact that the applicant failed to inform the planning board that it does not have water for this site. BB/WW property
No, I
or
understand.
anybody that was there.
You made
So
your
I
point.
object and I move to strike everything that he just said relative to expert testimony, as well as those
You
exhibits.
made your point. I don't think we're going to strike anything. The real question, though, is I don't believe it's appropriate to receive any additional information the day of an appeal when we can't interpret it. And it's also, give a quick response. And then
Yeah,
I'll-
no, absolutely. I agree with you. I mean, I think it's not protocol to receive items the day of. But these are not any other items. These are public documents. They're public documents in the domain. They're court documents. There's a decision from the Superior Court Justice. There's a Superior Court case. And there's an easement that's recorded in the land evidence records. And if the board chooses not to take it, they certainly can do that. But that only goes to my point, that the applicant had an obligation to present that information to the planning board, but it didn't. As part of this conceptual plan review, the applicant should have placed on its checklist, whether it had access to water. And these documents are, again, recorded in the land evidence records, and they're court documents.
Well, I think we understand that, but again, I think you can present it if you'd like. We're not going to interpret it because it's really not salient to the issue, which is you have stated, and if you could, just for a moment, take a step back. In our criteria, in our enforcement section, it's not verbatim, but it's close. It says that the appellant shall, quote, clearly and unambiguously state the issue and relief sought. What's very unclear, I think, to all members is that in your memorandum, in support of appeal, you use two words, modified and vacate. So please define what action it is that specifically the appellant is asking and appealing. Do they expect the planning board, the zoning board of appeal to, quote, modify, which you know is an impossibility, or to vacate?
So I was going to get to the relief, but let me go there directly. What I'm asking of the board is twofold. One is I believe that the decision that the planning board made should be modified. And I believe that this board, or I should say this board, should remand the matter back to the planning board. And you have several different powers that you can do. You can vacate a decision, or you can simply mandate a decision. You can vacate a decision, or you can remand a decision with direction to the planning board. And my relief is a little bit unclear, because the goal here is not essentially to stop the development. The goal here is to make the development viable, to make the development work within the existing fabric of the commercial intense activity on the site.
So with,
What I'm asking,
but with that being said, are we to strike the word modified from your memorandum?
well, you can strike the word modified, but I'm asking that the decision, essentially the planning board modify the decision, because it should allow for the review of other pertinent documents relative to utilities, and it should also permit for review of traffic, and it needs to focus on what the applicant is saying with regards to the drive-through and the type of trip counts, the codes, what's being used to determine the trip count. Now, the board can just vacate and leave the planning board to no direction, but I think that in this case, because it's an important case, because it involves a specific area of town which is important from a commercial perspective, I would ask that it would vacate the decision with direction that the planning board look at these issues, utilities and traffic. If the word modify bothers you, I have no problem modifying my argument or modifying my memo, or striking the word modify, and asking you to simply remand this decision to the planning board for further review on these two items. Now, before I get interrupted,
Let me stop everybody for 1 minute. I don't want my board getting confused. And I need to pull everybody back, and just listen carefully to me for 1 second. The standard of review, 45-23-70. You've all read it, you're all familiar with it. You're sitting as a board of appeal. It's established by this chapter in instances of Board of Appeals of review, and that's you, of a planning board decision or an administrative officer. Here's the planning board. The Board of Appeals shall not substitute its own judgment for that of the planning board or administrative officer, but must consider the issue upon the findings of the record of the planning board or administrative officer. And this is very important. The Board of Appeals shall not reverse a decision of the planning board except upon a finding of prejudicial, procedural error, clear error, or lack of supportive weight by the evidence of the record. It's improper to take into consideration any new evidence presented tonight, as the applicant has stated. So you need to disregard anything that's going to be presented by Mr. Mancini in terms of new evidence presented before the board. You're to focus only on the record. That said, Mr. Mancini's implying that you have an ability to give relief, or stating clearly that you have an ability to give relief based upon an ability to modify. I disagree with that. That's not correct. After you hear the arguments tonight, you need to make a decision whether to grant Mr. Mancini's relief. If you are to grant his relief as the appellant, then, and it's 3 out of the 5 of you that grant that relief, then it has to be, once it's overturned by the planning board, it has to be remanded back to the planning board at the stage that the planning board left off in the proceeding. And the chairman knows all this. I know I'm being obvious to the chairman, but I just want to make clear, I keep you on track here before we go any further. And that is the scope of your authority tonight. You've read both briefs. You need to consider it in light of both briefs and whether you feel it's proper to grant the applicant's relief. Mr. Mancini.
Yeah, if I may, I would disagree with you. So I'm not asking this board to modify the decision. I'm asking this board to vacate the decision and to remand it to the planning board on the basis of clear error. And I want to be clear. We're throwing a lot of things around. The error of this decision lies in paragraph number 9. And I've read it. Paragraph number 9 says that the applicant provided a complete traffic study performed by a licensed professional engineer. My argument is that traffic study was not complete. That was inaccurate. And I'm explaining why.
Attorney Mancini, if you could, though, when you first started, you referenced 2 items in the decision. Number 9, obviously, and there was one you very briefly, which one, what was the second one?
So there's 3. Number 4 is the finding of fact, which I don't disagree with, but I think number 4 is tied into number 9. So in order to find number 4, you have to have a traffic study that supports addressing the issue of number 4. Number 4 says that that section of highway is heavily traveled roadway, densely developed. It says roadway in a densely developed commercial area.
And your issue with that is?
My issue with that is number 9. That's a finding of fact. So in order to make that finding of fact, to satisfy that finding of fact, the planning board required a traffic study. The planning board then makes a finding that the traffic study, which supports their decision, is complete. It says it's provided a complete traffic study. That's inaccurate. It's not correct. The traffic study was.
Well, again, that is the crux of your appeal, that you feel that the traffic study that was provided by a licensed engineer is flawed in one fashion or another. However, I think for the record, we just need to just put to bed, if you will, the issue of the water and the easements in respect to our council and the applicant's counsel and what we know to be the truth. Those are moot points. They have no relevance. They have no relevance because you, in fact, on the record, stated what you attributed to some state judge. I think I heard that master plan approval is almost something you'd write on a napkin. That was somewhat like your analogy. So if your analogy is that it's somewhat like you'd write on a napkin at a coffee shop, then the issue of access to utilities is moot because that's what preliminary review is for. So it's not even applicable in respect to both councils. So we'll move on beyond that. In kind of summary, you've made it, I think, crystal clear in your presentation and also in your submittals that your issue is you believe the traffic study is flawed. But we also should probably note for the record, I mean, do you agree for the record that the planning board does not require a traffic study as part of master plan approval submittals.
I disagree with that. I believe in this instance they did.
Well, there's no record that they did because their application doesn't say traffic study.
If there's a record that they premised, so their decision is premised on number 9. That's the issue. So if they, if there's no evidence in the record that says that the planning board didn't require a traffic study, there's no evidence in the record that says that the planning board felt that the traffic study was gratuitous, that was an extra chip that didn't need to be considered. In fact, the opposite. That's why I say paragraph number 4 is very important, because the planning board determined as a final fact that there was an issue with traffic at that site. And this applicant would not have been able to move forward if they did not provide a traffic study. If there had been 0 traffic study, that would have only been more egregious.
Can you also acknowledge, though, for the record, that in item 1, based on the findings of fact, in the very same approval letter, it says that all necessary state of Rhode Island permits shall be issued prior to preliminary approval, including but not limited to, and I just draw attention to the RIDOT PAP permit, which is the, I believe, physical alteration permit, which in the documentation notes that that is inclusive of the review of any traffic study that's provided. So is that an accurate statement? So no matter what traffic study was submitted, in order for preliminary to even begin, RIDOT has to accept that traffic study as accurate. And you're alleging that if these egregious errors have been made by the planning board, whether it's directly or indirectly, that RIDOT, if they're doing their normal review, if it's such a glaring misrepresentation, they would flag it and say, we don't accept this. Is that not, can you not conclude that from that statement?
No, your statement's correct. I mean, for them to proceed to preliminary plan approval, they need RIDOT physical alteration permit. They also need RIPTES permit for DEM. My point is, you know, at this stage, if it's futile, why go forward and continue to follow down a fool's mission if you know at this stage that there's an issue, that there's a flaw?
Yeah, but you answered your own question relative to this board's legal responsibility. It's not for us to determine whether an applicant's on a fool's errand or not. This is a procedural matter.
It's your obligation to determine whether or not the planning board committed an error, whether the planning board whether the planning board issued a decision not supported by the evidence. The planning board issued a decision that was premised on a traffic study that's incorrect. And if that traffic study is just going to continue to go to the next level, incorrect, all you're doing is wasting time and money of the town, the applicant, and the butters.
No, I think I think all of us understand that, and we appreciate your observation, but the facts are as they are, and we would have to act accordingly. Are you finished?
I have
Any questions?
one question for Mr. Mancini. The chairman did catch one of the 2 questions I was going to ask, which is that this whole thing is subject to DOT approval. But the other thing is that the written study that's submitted into the record does acknowledge what you call the flaw. It does acknowledge the section that it's referring to and the statistics. And from my understanding, it's referring to a standards manual, and they acknowledge that the terminology that we use in our zoning ordinance is not the terminology that they use in the standards manual. That's how I read your article. So is there another standards manual that exists that would provide other information that would make this say this is a totally inappropriate standards manual? But you haven't made that argument.
No, the argument is this. I agree with you. The report itself acknowledges that the code used by the ITE is not consistent with the codes used within the town of North Smithfield. But my beef, if you will, with their report is they chose the less intense use. Rather than to round it up more conservative, more problematic vision, they chose the lesser route. And they did it to make it look easier. Well, I wouldn't say.
Perhaps they did that in their oral presentation, but they didn't do that in the written presentation. They provided both.
They didn't.
They did.
They
You lifted the statistics off of the manual in the report
No.
to show the higher statistics of the traffic volume.
But then they said, they added a disclaimer. They said, well, this drive-through is gonna be a restricted drive-through. And because the drive-through is gonna be for mobile uses only, it's therefore not a coffee shop / or
Well, I think,
casual restaurant.
I don't want to get too deep in the,
Drops the trip count.
I don't want to get too deep in the weeds here, because again, we're getting into the minutia of the detail, and we are not supposed to be the planning board interpreting whether statute 3, statute 4, code 5, or code 23 was used. You've made the presentation that you believe the traffic study was not properly prepared, and that you're referencing item 2, that the planning board made a clear error. That's the premise of the appeal. I don't think we need to prolong the matter. The only question I would ask you for the record to confirm is that if this goes through its path, if the appeal were to be denied, and the applicant submits and goes through all of their approvals, and they were to get a RIDOT PAP permit, and they open up preliminary approval process with the planning board, could not this abutter, who I believe is the appellant, could you not then have every opportunity to bring up all of these issues? I'm not going to talk about water because it's not in this relevance, but that issue could be discussed. The traffic study could be discussed again. But if it was approved by RIDOT, it would appear to be a moot point.
There's no question. So let me tell you how.
So if that's the
Let
case,
me tell you the process. So from here, we go to Superior Court, Superior Court, we go to Planning Board would come back here. The applicant's not going away. The applicant has multiple problems. We're addressing one at this stage, because as you identified, it's a conceptual stage. We're addressing traffic, because they brought traffic into the argument, into the discussion, because they needed to. You get the preliminary plan, there are gonna be a host of other arguments that ever would prelude you to. But for now, the focus is on whether or not the planning board should have relied on the traffic study that they were given for a concept plan that maybe DOA, maybe dead on arrival when we get bid, because the traffic study wasn't done. It hurts the applicant.
I think we understand. Okay, thank you, sir.
Mr. Chairman, members of the Zoning Board of Appeals, Michael Resnick on behalf of the applicant. Thank you for your attention this evening. I'm going to be really short in my presentation. We have briefed this voluminously. As I noted, there's about 160 pages of evidence in the record, including the expert report offered by our engineer that includes a traffic analysis as well as other materials. I want to be clear. There is absolutely no evidence that was before the zoning board whatsoever that this project would have an adverse impact on the surrounding traffic. There's good reason for that. Mr. Mancini was not here. There was no expert retained. There was no presentation whatsoever. So I say this with respect, but when a zoning board, sitting as a board of appeals, is confronted with expert testimony that was accepted by the planning board, and there is nothing in the record to contradict it or rebut it from a competent person, we're done. Now, this concept that the wrong use code was used, Mr. Mancini is not an engineer. He has no competency or qualifications to make that argument. If they wish to make that argument, they should have brought an expert and given your planning board the benefit of the arguments that they're making. I'm going to tell you what happened. They were hoping that they would get us on a procedural error, that I made a mistake on notice. And the reason why they didn't show up at the hearing is that's a free appeal. But you just heard him say there was no procedural error. So what are they to do? There's only one thing they can do. Mr. Mancini, who's a very eloquent, skilled attorney, is going to persuade you that the expert materials were wrong, that the evidence of record shouldn't have been relied upon. He's not competent to do it. Not only is he not competent to do it, it's not part of the record whatsoever. So this is a complete red herring. There is substantial evidence of record for this board to confirm what your planning board did. End of story. There's nothing else there whatsoever. The second issue is that it's an improper appeal, and it is an improper appeal for the reasons that your chairman honed in on. Just like water, just like utilities, just like traffic, there is no requirement that an applicant demonstrate hard engineering that includes a traffic report at master. The reason why we did it was my recommendation, because many times throughout the state, and Mr. Mancini knows this better than anybody, when you have a project and you know that ultimately a traffic report is going to be required, both before preliminary and before write-up for a PAP, you get out in front of it out of respect to planning staff and the planning board, and you provide a report so that you can get feedback. But the prism that it needs to be looked at is conceptual. The analogy of the napkin. Did my client go far and beyond that? Yes. Does state law require it? No. Did your local ordinance require it? No. Does the checklist require it? No. And as a result, this appeal is totally improper, because obviously we wanted to get feedback from the board. We did get feedback from the board. That ultimately is, that feedback is going into our physical alteration permit with write-up that we've submitted for. Mr. Mancini's client has the opportunity to take an appeal of that write-up PAP. They have the opportunity to come here, and instead of having Mr. Mancini very eloquently try to convince you of something, they can go get an expert who can go toe-to-toe with a professional engineer, and the planning board can make a determination as to who they credit. And then ultimately, an appeal may come to you, and you're going to look at that. So really, the issues here are twofold. One, there is no evidence of record to support his arguments. He's not competent to opine on what apparently is his primary argument, that the wrong use code was used. He's an attorney. I'm an attorney. Don't listen to anything that we say. Look at the record, because it's about the engineer. The second thing is, this is totally a red herring. It's master plan. We're going to probably be back before you at preliminary, because there's probably going to be an appeal like this. And guess what? At that opportunity, maybe Mr. Mancini and his client will make a presentation to the planning board and put forth some evidence to not ask you to do the impossible and the illegal, which is put your opinion over the zoning board when there's no evidence to suggest it. I'm happy to answer any questions, but that's the end of this thing. Thank you.
Any questions for Attorney Resnick?
No, I just wanted to address Mr. Resnick. My chuckle when you said, don't listen to attorneys, was, I practiced law for 27 years. I used to have a coffee mug that said, some of my best friends are lawyers, I just wouldn't want my sister to marry one. So it just hit me personally as an attorney, so.
I mean that with all candor. There are places, but the reality is that this is an exercise in persuasion. It's not evidence. And unfortunately, he's equipped with nothing. I have 160 pages that your planning board relied upon. And it includes a traffic report, it includes expert testimony. Where's your engineer? And I have nothing else. I'd be happy to answer any questions. Thank you for your
Anything further? Vinnie?
Wouldn't it be a lot cheaper for all concerned?
Your mic, Vinnie. Mic. No, push the
Press the
button.
red button.
Wouldn't it be a lot cheaper for all concerned, because this is gonna go on and on, it's gonna cost people a lot of money, they take a superior court, we have to spend lawyer fee, and it gotta go back to planning anyway? Would it be better to recommend this thing back to planning at this stage and make it a lot easier for everybody?
Well, we can't, it's not our job to decide what's
We can recommend it
easier
back
for
to
everybody. I
planning.
mean, we have to go by what was presented. We have to rule on all three of those items.
Mr. Archibald said we could recommend it back to planning.
Or we can do whatever we want, but we need to do what's in the law. We can't just come up with a reason. We have to find that clear, The applicant or the appellant is claiming that item 2, clear error. So we either have to define to the satisfaction of the members that clear error occurred. They've already acknowledged that there is no prejudice. Clearly, there's no lack of supportive evidence. So 2 of the 3 items that are the basis for any appeal are moot. So the only relevant factor is clear error. And whether they're going to appeal 6 times to Sunday, that's both parties' issues. That's a private matter. We have nothing to do with it. We have to focus on those 2 words, clear error.
I want to hear what Mr. Archibald said.
Yeah, I don't think you heard me accurately, Vin, respectfully. The only way it goes back to the planning board is if you overturn the decision of the planning board by granting Mr. Mancini's appeal and saying that he's correct. Then you remand it back, send it back to the planning board at the stage that it left off. That's the only way it goes back. You don't have the discretion to say, based on the arguments we're hearing today, we're not going to make a decision as a zoning board of appeals, but we're going to send this back to the planning board to continue. That's not proper.
And how much money they spend on lawyers is their decision.
Yeah. Okay, we still have the appellant's, the applicant's lawyer. Are there any further questions for the applicant's lawyer? Oh, thank you, sir.
Thank you for your attention.
Okay, I guess we formally have to close the presentation from the parties.
Yes.
So a motion to close the presentation from the appellant and the applicant, please.
I make a motion to close argument.
Second.
I'll second the motion.
All those in favor?
Aye.
All right, so we'll go into deliberation, and just as we do with our relief, when we're sitting as the review, now mind you, we don't do this on a regular basis, so counsel is here. If we need further clarification, then certainly reach out. But essentially, there are the 3 items, which is in the documentation. And I summarized it in my memo here, but it's procedural error, clear error, lack of support of the weight. And again, one of the most important factors is paragraph A of 10/6 Standards of Review. The Board of Appeals shall not substitute its own judgment for that of the planning board. So we cannot think, and again, that would be, well, gee, we don't want 17 appeals. We have to stick to the facts. So we'll go with number 1. Prejudicial procedural error. The appellant has confirmed on the record that they are not alleging that. So I think we can agree that there is no procedural prejudicial error. Are we in agreement on that?
Yes.
Agree.
I will leave the second one for last. Item number 3, lack of support of the evidence. Almost by definition of his argument, he's arguing that exact opposite, that it's the evidence that he's alleging is in error. So clearly, lack of support of the evidence is not relevant, in my opinion. Is that agreed?
That, and if you actually read the transcript of the hearing, you would see that the board actually asked about various other aspects of traffic that weren't directly addressed in
In the report.
the
Yeah,
report.
so it's the action was supported by the evidence.
Yes.
So item 2, which is the crux of the appellant's appeal, is that the planning board committed or clear error, whether that was with intent or not. Again, I think, for me, in a roundabout manner, I mean, clearly both councils acknowledged it, but there's some very basic factors here. We all know, depending on our level of experience and exposure to planning board, is that recovering from a cold. Master plan approval is the base level of approval. The least requirements are necessary to get over that first hurdle, and primarily then to seek relief from the Board of Review if you need relief. That's usually prior to January 1st, or up until January 1st of this year. That was the premise. We know that that's being changed, but the change is irrelevant. We know that the actual checklist from the planning board does not include the need for a traffic study. Now, of course, the applicant decided to provide it, and as Chris, as you have noted, it was discussed in the minutes or in the verbiage. And again, we're not supposed to, whether we read it and we agree or disagree with the appellant, whether it's code 27 or code 26, it's not ours to say that code 26 or code 27. I hang my hat on item 1 in the findings of fact from the planning board, which clearly states that before preliminary approval can occur, all permits shall be issued, which is inclusive of the RIDOT physical alteration permit. So if RIDOT reviews the traffic study, and if it is so profoundly and fundamentally flawed, and RIDOT doesn't flag it and say, hey, this is grossly in error, it must be fixed. Or if the appellant decides to go to RIDOT and say, hey, we have this issue with the traffic study that was approved. We want you to look at those numbers and as traffic study minutia. That's where this matter needs to be adjudicated. And then it can be appealed at that point, and preliminary approval begins. And all of these other issues, which whether they're salient to us or not, water, utilities, those are issues for the planning board, not for the zoning board of appeal or review. So I really hang my hat on the fact that this matter will be adjudicated by the RIDOT PAP permit review. And then further, if the appeal is not granted, further during preliminary review, anything that needs to be flushed out can be flushed out. And again, it's not for us to be concerned about whether the applicant knows he's got issues, the appellant knows the applicant has issues. It's not relevant. The question is, was there clear error? My opinion is I don't believe there was. Do we have
No, clear
further?
error to me would be like, in the decision, they cite 2 land use goals that are fulfilled by the proposed project. If the appellant's argument would have been, well, land use goal number 3 was totally ignored, that's clear error.
Or it's a business use and you said it was residential or
Right.
whatever,
Right.
something to that extent.
To me, I can't get past that this is just a decorated way of asking us to substitute the judgment of the board.
Which
The
yeah.
board was there.
Yeah.
They took the testimony. They were in the best place to evaluate and make
Yep.
a decision. And there's nothing that's been presented by the appellant that demonstrates, to my thinking, that there's a clear error by the board.
Okay. Anything else?
No.
Okay. Vinnie,
Nice.
Stephanie, you said your piece. Anything? No. Okay. Well, with that being said, I think we can close. Before we close, we should note that we may as well stay consistent. Normally, we write the decision in the affirmative. So we can, you can write a decision to approve the appeal, and then we either vote, a vote against is to deny the appeal. A vote in favor would be to accept the appeal or grant the appeal. And I don't think it has to be more than a sentence, right? You can reference the planning board memorandum or letter of decision, which is the crux of the matter, which would be, right, the Exhibit B, the October 3rd decision letter of the Town of Smithfield Planning Board. Do we have an appeal case number, Leo, or is it, I mean, if we wanted just to be technical?
I don't think you had any appeals over the last year. When was the last time we? had
Yeah,
some
it's
Board
been
of
a
Appeals?
while,
if you're gonna,
so, yeah. So
you
we'll
know,
call it the
ascribe a
ZBA.
number to it,
Yeah,
it'd probably
ZBA
be-
0123, how's that?
Right. That works.
And again, it's per the Article X, it's 3 of 5 as required. Minimum of 3 to reverse any decision. So again, if this motion is made in the affirmative, to accept the appeal, a yes vote is accepting, a no vote is denying the appeal. To get him a tablet.
Oh, me? You're waiting for me?
Oh, I
thought you were, who,
I thought you were
oh,
writing the
oh,
motion.
no,
I was
no,
writing
no.
it.
No, I thought, I looked at you, I was,
Oh.
yeah.
I didn't bring papers with me.
Well, Chris, you want to write it, the lawyer?
Yeah, I'll take it.
Okay,
I'll
it's,
take a
we'll
stab
call
at
it ZBA, oh, my mistake, I just looked at you and assumed.
I make a motion to grant the appeal of BB/WWLLC, appealing, seeking to vacate the decision of the Town North Smithfield Planning Board dated, do you have the decision there?
Yeah, dated October 3rd,
Dated
2023.
October 3rd, 2023, and filed with the Court of the Clerk on October 19th, 2023.
For the Prime Healthcare Landmark MOB HC 116 Eddie Dowling Highway LLC. And it's the decision letter. It's essentially approval of the master
so-
plan. So they're appealing the approval of the master plan for that owner. And a decision dated October 3rd.
Okay, let me just. So I make a motion to approve the decision letter,
No, the appeal,
the appeal
to overturn
of
the decision.
Right, okay.
Yeah.
BBWW, LLC, seeking to overturn and vacate the decision of the Town of North Smithfield Planning Board's decision dated October 3rd, 2023, and incorporate same into a decision letter. Close enough?
Yeah, can we read it again slowly, or did you didn't read it, but it's, I just want to make sure we have it. Did you record that properly? Or?
I'd like to hear it again.
Yeah, okay.
I don't know if I can say it again. I make a motion to approve the
Appeal,
appeal of BB/WW, LLC, seeking to vacate the decision of the Town of North Smithfield Planning Board, decision.
approval, master plan
decision
approval, yeah, decision letter
Concerning-
dated October 3rd.
Concerning the decision, letter dated October 3rd, 2023, applicant Primary Healthcare Landmark, MOB, and HC 116 Eddie Dowling Highway, LLC.
Okay, I think that's clear enough. Does that, everybody understand? The motion is to grant the appeal, to deny, overturn the decision letter, the approval for the master plan issued by the planning board on October 3rd for that Prime Healthcare MOB 116 Eddie Dowling Highway. And we know that the appellant was listed correctly, so. You guys good with that?
Well, it's real simple. I think the motion's properly before the board. There's been a lot of different tenets put into creating that motion a moment ago. why don't we reiterate the motion one last time, so it's crystal clear, without any breaks, and then when that's properly before the board, you vote on it.
Okay.
Okay, you think I would get it on the fourth time? All right. I make a motion to grant the appeal of BB/WW, LLC, seeking to vacate the decision of the town of North Smithfield's Planning Board's decision letter dated October 3rd, 2023, regarding the appellant,
Applicant.
Applicant Prime Healthcare Landmark, MOB and HC 116 Eddie Dowling Highway LLC.
Concise, everybody understand?
That clear to all of
Okay.
you?
Fifth time's a charm.
Could you imagine, I'm not a lawyer, if I had to
All right, we'll have a roll call vote.
Mr. Najarian?
No.
Mr. DeZiel?
No.
Mr. Mostyn?
No.
Mr. Macchiantonio?
No.
Ms. Benoit?
No.
Okay. The last item on the agenda is the motion to adjourn.
I'll make a motion to adjourn.
All in second?
I'll second the motion.
All in favor?
Aye.
Okay, thank you.
Thank you, members of the board. Have a good night and holiday.
Thank you. You too.
Merry Christmas.